Welcome to the Probate Nation. My name is Richard Ruddy and I'm the host this evening for this show. The goal in each show is to inform, highlight, and educate you about the issues, challenges, and pitfalls you may face in probate, both in a living probate and the probate of a decedent's estate. A living probate involves a court-appointed conservator and guardian who is charged with handling the finances and care of an elderly person. On the other hand, the probate of a decedent's estate involves a court-appointed executor or administrator who is charged with probating the estate of a deceased person, and it is this probate process that we will cover in this show. When someone passes away, probate of that estate is the process to transfer the title or ownership of probate assets to the beneficiaries of the decedent. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of a decedent's estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. Our program today introduces you to the legal document that typically starts the probate process to convey those probate assets, and that is the written last will and testament executed by the decedent and admitted to probate in the local circuit court. This program will discuss some typical will provisions as well as practical issues to consider with each of those provisions. Our first guest is an attorney with the law offices of Michael D. Tubin, PC, in Annandale, Virginia. His practice is general in nature, with an emphasis on estate planning, special needs estate planning, administration of estates, and real estate law. He is a member of the Academy of Special Needs Planners, the Board of Directors of the Disability Law Center of Virginia, and a member of the Fairfax County Long-Term Care Coordinating Council. He is a former member of the Board of Directors of the ARC of Northern Virginia and a former adjunct professor of the American University. He lectures extensively on estate planning matters and is a contributing author to several books on elder care, probate, and estate planning. Our second guest is an attorney with the Ruddy Law Firm located in Fairfax. He focuses his practice in estate planning, probate, and estate administration. He is a member of the Fairfax Bar Association and its Continuing Legal Education Committee, a regular speaker at seminars on probate and estate administration, and the associate publisher of the Probate Nation website. Please welcome attorneys Mike Tubin and David Nur. Fellas, welcome.
Thank you, Richard.
Thanks for coming over.
Glad to be here.
Well, we're going to talk about the most basic document we have to deal with in estate planning and probate, and that's the will. Michael, what is a will?
Well, a will is actually pretty much the last document you ever need as a person. It's termed the last will and testament, and each word actually has some meaning. In very simple terms, by saying the last will, it's the last will you write. You can write wills more than once. You could amend wills. You can revoke wills. But the last will is usually the one that will be going through that probate process. The will is basically what you will, what you want, what you desire, as far as transferring assets to named beneficiaries. When I look at the word testament, I think of the word testamentary, which means takes effect upon death. So you write your will while you're living, obviously. You put it in a nice, safe place. It literally collects dust until you pass away, and that document now springs to life.
Okay, so we talked about what is a will and why we make a will. Who can make a will?
Pretty much any person can make a will. The two basic requirements are you must be an adult. So in Virginia, that requires you to be over the age of 18 years. And you have to have some basic competency. Basically, you need to know what you own as far as assets, who you'd like to give those assets to. And if you know those two things, you could essentially write a will. The standard for competency is not that great, as you could hear from just those two requirements.
Okay. Well, David, what does a will control?
Your will is going to control your probate estate. So just for sake of differentiation, there's also non-probate assets. So non-probate assets would be, you could have a bank account that has a payable on death or transfer on death designation. You could have maybe a joint account with right or survivorship. Those kinds of accounts, those types of assets would pass by operation of law to the survivor or whoever you named as the designated beneficiary. So oftentimes, say for retirement accounts, you'll have a designated beneficiary that you name to receive your retirement assets when you pass away. So the probate estate is looking at those assets that are owned by the decedent upon his death. So we could be talking about joint property or multi-property accounts, but they would have to not have one of those payable on death designations or a right of survivorship. Typically, we're talking about accounts just held in the decedent's name or real property held in the decedent's name. And those would be the assets that we're kind of focusing on as far as the probate estate.
Okay, so that's what the will controls. So what if someone doesn't have a will, David? What happens?
So if somebody doesn't have a will, then we're looking really at letting the laws of Virginia decide what's going to happen to that person's property and who's going to oversee that process. So the laws of Virginia talk about have intestate succession. So typically the decedent's property would pass to a spouse if they leave a spouse that's living. And if there's children that aren't by the surviving spouse and the decedent, then it would pass 1/3 to the surviving spouse and then 2/3 to the decedent's children. And then beyond that, we're kind of going down through the descendants if there is no spouse or children. So we're looking at grandchildren. And then there's no grandchildren, then it goes back up the family tree to look at the decedent's parents, and then back down looking at siblings, nieces, and nephews. So it kind of goes up and down the family tree looking for the closest living relatives.
So basically, the state of Virginia and many states have written a will for you if you don't write a will for yourself.
Yeah, that's right.
Basically. Well, let's turn to some of the important provisions we would put in a will. So one of the big things for many young parents, of course, is to make sure who's going to be the guardian of their children. Is that something that can be addressed in the will?
Yes, absolutely. And that very well might be one of the main reasons a lot of parents with minor children come in to write a will. Mm-hmm. So that is something that's usually addressed. Typically, they'll name somebody, and that it should be noted that whoever they name, it doesn't put them ahead of a parent. If that parent is fit to take care of the children, and one of the parents pass away, and they named another individual to act as a guardian, it doesn't mean that that person's going to step in front of that parent. It just means that if there's nobody to take care of that child, no living parent, then it will go to the named person.
How about tangible personal property? Are there provisions to deal with that?
So for tangible personal property, what we usually do for clients is we'll use what's called a personal property memorandum. And in the will itself, it will incorporate this separate document into the will. And on that, it will list the property, who you want it to go to, and then when the decedent passes away, the executor of that will then make sure that that tangible personal property goes to the person that's listed.
Okay, that sounds good. How about specific bequests if I want to give somebody $1,000? Is that an important provision?
Yeah, so specific bequests are usually found probably in the earlier sections of a will, and people can transfer to beneficiaries of their choosing real estate, tangible personal property, and also money. Okay. So those are definitely done through a will.
And so from a probate perspective, when I give away tangible personal property, if I give away cash, should I get a receipt signed by someone so that I could prove that I did that to the Commissioner of Accounts? Yes,
absolutely. And the Commissioner of Accounts will look for this when the executor goes to file the accounting. He's going to look for an original signed receipt from the beneficiary saying that they received maybe the property from that specific bequest, so that money or that tangible personal property.
Okay. Well, we talked about tangible personal property bequests, some specific bequests we give to people. So then we have what's called a residuary bequest. Okay, what is that, Michael?
Okay, the residuary bequest is the distribution of what's left over in the estate assets.
Okay, so that's what's left. And again, when we make that distribution of that residual bequest, do we need to get a receipt of some kind signed by those folks?
You still will. It could be a more general receipt. Let's say there's 3 named residuary beneficiaries. Mm-hmm. They could all pretty much sign a similar receipt saying they've received their share of that part of the estate.
That's a good idea. Now, sometimes these bequests, when we get down to the residual bequest, it takes everything else that has not been given away, but sometimes those can fail in some way. Is it important to have a sort of beneficiary of last resort named in the document?
It's always a good idea to have successor beneficiaries, sometimes called the ultimate distribution provision in a document, because you still want your desire to be carried out. So if the initial people are not available, for example, they may have predeceased the decedent, then it's always a good idea to have successor beneficiaries.
Good, good. Let's switch gears now. Of course, we talked about the will and what it says, but someone's got to be in charge of that, okay? So that person get called a bunch of different names, but typically, it's in a case of a will, it's called an executor, okay? David, what is an executor?
So just as you said, it's the person that you're putting in charge of administering your estate. So lots of times people will choose their spouse first in line to act as this person, as the executor. If they have children and the children are adults and grown and they trust children, they might put their children as executors. So this is the person that you're kind of entrusting to administer your will.
And can you name co-executors?
You can name co-executors. I think people oftentimes, especially if they're talking about their children acting as executors, and maybe they have two children, both adults, and they can get along well enough to administer the estate, then oftentimes they will name them as co-executors.
Okay. And then beyond that, of course, we always want to make sure we name a backup to those folks in case no one is there, what's called the successor executor. Now, Michael, can a non-Virginia resident serve as an executor?
Yes, the law permits that. In fact, when I discuss that issue with clients, and then they may ask that general question, specific question. My brother in Oklahoma, I really like
Sure.
him to be the executor of my estate, but is that permitted? And my pet answer always is name the person you want. If it is a non-resident, there's ways of either naming a co-executor who would be a resident, or you could actually just name a resident agent for service issues, and you still have the person you want to be your executor.
Now, whenever we do these wills, there's always the issue whether someone should be bonded or not. Do you have to be bonded in order to qualify as an executor?
Again, there's no legal requirement. In fact, most wills where we're dealing with family members, it's pretty common to put a clause in the will stating that no bond, no surety bond is required for the executor, and the clerks will honor that.
Sure. So the will would say that it waives surety.
Correct.
Now, in some cases, if they don't waive surety, then they have to be bonded by a bonding company, and we have to make sure that they're credit worthy. Now, do executors have to account to the Commissioner of Accounts?
Yes, that's one of the fun jobs of being an executor of a probate estate, dealing with the Commissioner of Accounts office, where there are legal requirements for the filing of specific documents. Inventory initially is a document first filed, and then potentially one or up to two or more accountings. In other words, the executor must account to every penny, literally, of the assets under the purview as executor.
Now, David, we're in a show that talks about probate, okay,
Sure.
and one of the things is you have to ask, is there some way to minimize the probate process even when you have a will, through maybe the selection of your executors? Can you talk about that?
Yes, you can. So getting back to the situation where maybe you have two children who will be acting as co-executors. If you have two children that are also going to be the residuary beneficiaries under the will, so the two children are going to receive all the property after any tangible personal property or specific bequests have been made, then they can file what's called a statement in lieu with the Commissioner of Accounts after the inventory has been filed. So this will avoid having to file those annual accountings, which you have to account down to every single penny to the Commissioner of Accounts what's been going on during your administration.
So that's a good thing to consider. Now, are there any practical issues associated with naming 2 or 3 or 4 co-executors?
Sure, and this is something that we've seen a lot in our office recently. So many major banks have started to kind of push back a little bit on this when you have multiple co-executors. They don't want that many people on the account. So say you have 3 executors, co-executors, they will not allow you to open an estate account because they don't want to have, I guess, really the liability of having that many actors on the account. So in those kinds of circumstances, it can kind of come back to haunt you a little bit. And we've been actually having to go to court to file a petition in order to have the court say that we could open an account with 3 co-executors.
Interesting. Now, I knew, though, that we had this discussion that you couldn't actually put in the will a provision that says any one of them can act unilaterally, and that may very well help in that situation.
It could.
Mike, let's talk about the power of the executor. Now that someone's been appointed again, you started to tell us a little bit about that. What type of power does an executor typically have?
Pretty much the authority to handle whatever assets are, again, under the control of the executor. There's statutory language in the Code of Virginia. Most lawyers just cite that specific statute. I sometimes think some lawyers get paid by the page because they'll actually write the entire statute out. But there is, as I said, a code provision. It grants very broad authority to be able to act because, again, we're not sure what assets are before the executor.
Sure. Now, in the case, if it turns out that the will does not, if the will is silent as to that statute and doesn't incorporate that, are there ways to obtain those powers?
There are. It requires a court order. Quite often, if a person might write a will without the assistance of an attorney, they may skip that provision. And if there's no authority in the will, then the executor really cannot do a whole lot. The biggest authority, the biggest power would be to deal with real estate, for example.
Sure.
So you'd have to petition the judge to grant that authority.
Sure, and that typically is not a difficult process to do. But
It's not, but it's an added time delay and an added expense.
Sure, sure. Dave, let's turn, we were talking about the last will and testament. Let's talk a little bit about the forms that a will can show up in your offices, okay? So there's a thing called, we learned about this in law school, the holographic will. So what is that?
So a holographic will is a will that's entirely in the handwriting of the testator. You don't see this a whole lot, but it does happen from time to time. And not every state in our country will permit a holographic will, but Virginia does. So this is a will that will be entirely in the handwriting of the testator, and it's accepted. It could be as simple as one page of writing, and that's it.
Still needs to be witnessed by a couple of witnesses, right?
So it doesn't need to be witnessed, but you will have to have two people during the probate process say that, two disinterested witnesses come down to the probate and say that, yes, that is in fact the testator's handwriting. So that's one way that it's proven.
Okay. Well, Michael, let's talk about the typed will. Okay. What does that, other than to say it's typed, what form does that normally take?
Well, most wills today are typed, usually by computer today. The lawyers have a computer, or an individual can prepare their own. So the will is in typed form. The requirements there, again, are two witnesses must witness the signature of the testator. And there's an optional provision which we call a self-proving affidavit. At that point, the witnesses and the testator sign their signatures before a notary. And that minimizes the need to locate those witnesses when the will is actually probated.
So that's a really helpful thing to do and help expedite the process of getting the will admitted to probate typically.
Yes.
Okay. Well, let's talk about some common problems, okay? David, what are some of the common problems and mistakes that you're seeing with people who prepare wills?
Sometimes it's not knowing what assets or accounts are actually owned by the decedent. This can be solved, and it's very helpful to the person who's going to be acting as your executor when you do this if you create a list saying, these are the accounts, I hold them at these banks, these financial institutions, even if you can provide some account numbers. So they have something to go off of rather than coming into this blindly and then having to figure out by pouring through your paperwork, stuffed in your desk at home, what assets you may have, and it could be real estate accounts, it could be all types of stuff.
Okay. So, and of course, is it helpful to know where the will is?
Yeah.
Michael had mentioned that as well.
Yeah, so Michael mentioned it earlier, but it's very helpful to actually know where the will is. So with our clients, we'll have a book that contains signed copies of all of their documents, and in that is a page that's, where they can say where the will is located. We usually advise clients to keep it in a safe deposit box, or maybe a fireproof safe at home at the very least. But you have to also leave a note as to where this can be found. And you can also tell your executor where you plan to keep it ahead of time as well.
That's good to know. Now, Michael, what happens if we can't find the signed will?
Okay, it's a very interesting issue. a will must be an original document normally to be probated.
Sure.
But there can come a time when that original cannot be located. And the law in Virginia is fairly clear on this point. If the original will was always in the possession of the testator and it cannot be located once that person passes away, the law presumes that that person destroyed or revoked the will. And it's a rebuttable presumption, and therefore it would require the individual who wants to present a copy of that will, if that luckily is located, to be able to file a petition in court and convince the judge that the copy is a true copy of the original and that the testator did not revoke or destroy the original, and that they would have known that through either conversations with the decedent, this conversation with other family members, and it's a very major issue if the will is very specific in treating certain, let's say, family members differently.
Sure.
It could be a very contentious issue, but there is a way to permit the copy of a will to be probated.
And the importance to draw from that discussion is that, again, if we don't have a will, then the assets are going to be disposed of pursuant to intestate succession. And that statutory disposition may be starkly different from what was the written will provision.
Correct.
And that's where the controversy can arise.
Yes.
And where lawyers get involved.
Oh, yes.
For good or for bad. Well, we've covered a lot of stuff here. There's just, we talk about probate in this show and the good things and the bad things that can happen, and how to get through probate without pulling your hair out. But having a will and what you put in your will becomes extremely important. So I wonder if you guys could take a couple minutes to just share some final thoughts about things you suggest folks do in the course of actually getting their will prepared. Michael?
Again, think seriously about how you want to dispose of your property. One issue we didn't mention deals with minor children. If you have minor children, and even with a simple family will where husband to wife, wife to husband, but then to children. So if the children are minors, you need to deal with that situation. There's something called the testamentary trust that you could put in your document, and that's good. Whether you believe your children are mature enough at age 18, age of majority, or well beyond that. But again, it's your will, it's your desire to be able to state exactly what you want and how you want your property distributed upon your death.
I think that's a very good point. We certainly emphasize that fact because depending on how much money you're leaving to that child, even if they're age 18, you have to ask yourself, what would you have done with that money when you were age 18? And most people respond that probably maybe it's a good idea to go ahead and hold that in trust for a while.
Exactly correct.
So, David, how about yourself? What's been your experience with some things we want to make sure we deal with, some practical problems you've seen in use of wills?
Sure. The thing I wanted to speak about is actually kind of a newer phenomenon, which is as more and more of our lives move online, we have these digital assets, whether we're aware of them or not, that also need to be handled in your estate planning documents. So they might need to be mentioned in your will. And so you'd want to have your executor take care of these assets. So these things can be videos and photos that you have stored on your hard drive at home, or they could be maybe in your Facebook account or Instagram or some other online service that you use. But these are assets that you hold. And so just like any other assets, you would want these to go to maybe certain family members when you pass away. So those should be recognized and handled in your estate planning documents as well. So that should be mentioned in your will.
That's a very good point. I know we had Sharon Nelson and John Simic from Sensei on talking about digital assets several shows before, and that's an area which is just changing rapidly. People are coming to grips with it because 10, 15 years ago we didn't even think about that, and yet now most of our lives are available for everybody to see online.
That's
with
right.
Facebook and some of those phenomena. Well, guys, I want to thank both of you for taking the time to come and talk to us. This has been great, very, very helpful information for all of our viewers, and thanks for being part of this public service to the community of Northern Virginia.
Thanks for the invitation.
You're very welcome. The question I have after listening to this program is this: should everyone have a will? And the answer is yes, for the following reasons. You get to decide who gets to your probate assets when you die, not the Commonwealth of Virginia. You get to decide who will be appointed by the court to probate your estate, not some local circuit court probate office. And finally, you can add some key will provisions to minimize the time and cost to probate your estate. You know, preparing a will is not something that you should do on your own. Too many things can go wrong. Instead, I strongly encourage everyone to consult with a local trust and estate attorney. Work with that attorney to prepare a will that fulfills your wishes so that you have the peace of mind that all will go as you planned when the time comes to probate your estate. This brings us to the conclusion of our show. We hope you found it informative. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.